Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath or affirmation, bills brought from the House of Representatives, petition, papers.
Minister of Rural Development and Local Government.
Thank you very much, Madam President. Madam President, I have the honor to lay on the table the following papers as listed on the order paper and supplemental order paper in my name. The ministerial response of the Ministry of Rural Development and Local Government to the 14th report of the Joint Select Committee on Local Authorities, Service Commissions and Statutory Authorities, including the THA, and an inquiry into the financial oversight and financial management systems at municipal corporations. The ministerial response of the Ministry of Rural Development and Local Government to the 8th report of the Joint Select Committee on Land and Physical Infrastructure on an inquiry into the effectiveness of measures in place to reduce traffic congestion on the nation's road. Thank you, Madam President.
Minister of Communications.
Madam President, I have the honor to lay on the table the following paper as listed on the supplemental order paper in my name. The administrative report of the National Library and Information System Authority for fiscal year 2016 to 2017.
Leader of Government Business.
Thank you very much, Madam President. Madam President, I have the honor to lay on the table the following papers as listed on the order paper and the supplemental order paper in the names of the Minister of Education, the Minister of National Security, the Minister of State in the Office of the Prime Minister, and the Minister of Social Development and Family Services. The ministerial response of the Ministry of Education on the 21st report of the Public Administration and Appropriations Committee on an inquiry into the oversight of state agencies under the purview of the Ministry of Education and funding to private secondary schools institutions. The ministerial response of the Ministry of National Security to the 8th report of the Joint Select Committee on Land and Physical Infrastructure on an inquiry into the effectiveness of measures in place to reduce traffic congestion on the nation's roads. The ministerial response of the Office of the Prime Minister to the 13th report of the Joint Select Committee on Social Services and Public Administration on an inquiry into the prevalence of teenage pregnancy and the state's capacity to minimize the occurrence of teenage pregnancy and provide services and assistance to teenage parents. And finally, Madam President, the ministerial response of the Ministry of Social Development and Family Services to the 15th report of the Joint Select Committee on Human Rights, Equality, and Diversity on the current provisions for the education of children who require special education programs and services in public, primary, and secondary schools.
Reports from committees.
Minister of Agriculture, Land and Fisheries.
Madam President, I have the honor to present the following reports as listed on the order paper and supplemental order paper in my name. The fourth interim report of the Joint Select Committee appointed to consider and report on the Miscellaneous Provisions Local Government Reform Bill 2019 in the 5th Session, 11th Parliament, and the report of the Special Select Committee of the Senate appointed to consider and report on the Evidence Amendment Bill 2019. I thank you.
Mr. Vice President.
Madam President, I have the honor to present the following report as listed on the order paper in my name. The second interim report of the Joint Select Committee appointed to consider and report on the Constitution Amendment Tobago Self-Government Bill 2018 in the 5th Session, 11th Parliament.
Senator Mark.
Thank you, Madam President. To the Minister of Finance, can the Minister indicate whether the recent change by Moody's of the credit ratings of Trinidad Petroleum Holdings Limited and the NGC from a stable to negative outlook will adversely impact the cost of borrowing from both companies?
Minister,
both companies.
Minister in the Ministry of Finance.
Thank you, Madam Chair, Madam President. Madam President, the Moody's did not change the rating of either company. The rating remains consistent to what it was last year. What has changed is the outlook for those companies.
Minister, through you, Madam President, whether access to international capital by both Trinidad Petroleum Holdings Limited and NGC will result in a higher rate of interest being charged on loans that are accessed by these two bodies. Madam President.
Minister.
Madam President, the companies, which especially Petrotrin, because we have example of Petrotrin going out to refinance last year when its rating is consistent with what it was now, and it managed to secure a loan to refinance its existing credit at reasonable rates and without government guarantee. Having regard to the fact that the rating has not changed, we do not expect a negative impact of the change in the outlook, which is caused by the coronavirus impact on the borrowing capacity or interest rates being charged to the companies. Thank you, Madam President.
Senator Mark.
Madam President, can I ask the Honourable Minister to share with this Parliament what was the rate of interest accessed by Trinidad, by Heritage, on the international capital market that she made? No, Madam President, arising out of the question. I'm asking a question.
Yes.
She gave a response.
Yes, that
so
was part of it. But that question does not arise, Senator Mark. Next question, Senator Hussain.
Thank you very much, Madam President. To the Minister of Foreign and Caricom Affairs, given the statement by the U.S. Department of State that this country should withdraw from the Rio Treaty if it does not wish to abide by it, can the Minister indicate if the government intends to withdraw from said treaty?
Minister of Foreign and Caricom Affairs, you have 2 minutes.
Many thanks to the Council. Madam President, recently, only but last week, this matter, meaning whether Trinidad and Tobago should cease being a member of the Rio Treaty, was the focus of a question to the Honourable Prime Minister during a press conference. The Prime Minister responded pointedly and in clear and articulate terms. Madam President, the government of Trinidad and Tobago, of course, continues to persevere notwithstanding local efforts to counteract the foreign policy of Trinidad and Tobago. The government is insistent and resolute in safeguarding the welfare of our population. Attempts to foist any other policy upon us is tantamount to undermining the foreign policy of Trinidad and Tobago and imperiling the welfare of citizens and the protection of the national interest of Trinidad and Tobago. Contrary to logic, the stated position of Caricom and the Charter of the United Nations, some right here in Trinidad and Tobago have decided to recognize the leader of the National Assembly as the President of Venezuela. Much flows from this interference in the mandate of our duly elected government. The potential for increased vulnerability of our country in this period is highly unfortunate. Madam President, attempts to thwart the attainment of the foreign policy objectives and development goals of Trinidad and Tobago to the detriment of citizens and residents must be resisted. The government continues to act as a bulwark against success in any such attempts. In this, the population can find some measure of comfort. Thank you.
Madam President, with all due respect, the Minister didn't answer the question. But, Madam President, I'll pose a supplemental question, and that is the government's position that they will abide by the articles of the treaty and the decision of the OAS in order to restrict travel, in order to abide by the restrictions being placed on member states who are part of the Rio Treaty. For example, restrictions on
Senator Hussain, ask a question clearly and concisely.
Can the Minister then indicate, Madam President, whether it is the government's intention to abide by the articles of the treaty and decisions taken by the OAS?
Minister.
Madam President, is somewhat muffled, but totally in harmony with the first part of the question that I resisted to respond to. I would not be a party to ignorance. Thank you.
Senator Hussain.
Nonsensical response given by this Minister, Madam President, when we are discussing such an important matter of public importance.
Members, please, Senator Hussain, have a seat. When you want to ask a question, ask a question. There's no preamble to it, there's just a question. Ask a question.
Madam President, can the Minister state whether or not it is the intention of the government of Trinidad and Tobago to abide by the travel restrictions placed on Venezuelan officials and companies of Venezuela, Madam President?
Senator Hussain, I won't allow that question.
Questions on notice, questions for oral answer.
Leader of Government Business.
Thank you very much, Madam President. Madam President, the government is pleased to announce that it will be answering question 111, 117, 146, and 148. We ask for a deferral of question number 112, 147. Thank you very much.
Questions number 112 and 147 are deferred for 2 weeks. Senator Mark.
So that, may I seek some clarification from you?
Perhaps you can.
Question 96 on?
I think the Minister indicated that he's not in a position, that question will not be answered today.
But did he indicate when it will be answered, Madam?
Well, Senator Mark, let's deal with that at the end of the question.
Which one do I ask, ma'am?
So you're free to pose question 111.
Yeah. Question 111 to the Minister of Energy and Energy Industries.
Minister of Energy and Energy Industries.
Thank you very much, Madam President. Madam President, public pronouncements have been made by both the NGC and Methanex relative to the ongoing negotiations between both companies which are parties to the contract. Both parties have issued a clear statement confirming their commitment to reach an agreement. There was in place an extension of the interim arrangements until 31st March 2020 to facilitate an agreement. Prior to the expiration of the last interim agreement, Methanex took the decision on March 16, 2020, to idle its Titan plant at Point Lisas. This decision was taken as a result of the significantly reduced industrial demand globally for methanol, which also prompted a similar decision by Methanex in respect of its Chile 4 plant in Chile. These plants are part of the global portfolio of Methanex and are likely to remain idle until the methanol market rebounds. Despite the idling of the Titan plant, discussion between Methanex and NGC continues and remains focused on arriving at a long-term contract, reflective of the current and projected market dynamics. The government remains available to support the efforts of both the NGC and Methanex in arriving at agreement.
Senator Mark.
Can I ask the Honourable Minister whether the National Gas Company has a timeline for arriving or concluding a gas contract agreement with the Methanex?
Minister.
The NGC, both parties have to agree. What is being placed on the table now, there are some differences because the market conditions has changed so fundamentally that it is affecting the pace of the negotiations. Methanol prices are now, this morning it was $219 per metric ton. Just January last year, that same price was $350 per metric ton. So the international global economy is affecting the petrochemical business. There's something called the gas value chain, which is currently being addressed, and these are sensitive commercial discussions that are taking place between two sophisticated commercial entities. And all I will ask the opposition and the country by extension is to understand these are complex commercial negotiations and all will be revealed in due course. The government is committed to finding a settlement.
Senator Mark.
Madam President, in light of the market conditions outlined by the Minister, can the Minister indicate whether once these conditions have stabilized, there is every likely possibility for an agreement for gas supply over a long-term period between the NGC and Methanex?
The answer is most definitely.
Can the Minister indicate whether, Madam President, the changes in natural gas prices has contributed to the delay in arriving at a gas contract between the parties?
Minister.
Obviously, there are differences of opinion between Methanex and the NGC with regards gas pricing. That is the basis of the negotiation. What affects gas pricing is twofold. Gas pricing is indexed to methanol prices on a price curve. It is also cognizant of what you pay upstream for gas. So all these things works out itself into a matrix that has to be analyzed very, very scientifically to come to where the sweet spot is, as it were, to find out what will be the settled gas price. And these are where the complex negotiations take place. And these discussions cannot be aired in public.
Senator Mark.
Madam Chair, can I ask the Honourable Minister whether the upstream cost or price of natural gas, which is sold to NGC, is being looked at by the government for some degree of renegotiations with the upstreamers that initially has resulted in this complexity that the country is facing?
The answer to that is an affirmative yes.
And can,
No, that's it, Senator Mark. Next question.
Thank you. Which question I go to?
117.
Yeah, question 117 to the Minister of Public Utilities.
Leader of Government Business.
Thank you very much, Madam President. Madam President, the government, and by extension, the National Training and Security Company Limited, better known as MTS, is committed to good industrial relations. In this regard, we have adopted a proactive approach in dealing with industrial relation issues. A major focus in this regard has been the holding of non-crisis meetings periodically with employees' representatives to appraise and update them on issues of concern. In this regard, two major issues of concern have been: one, the delay in submitting remittances on behalf of workers to certain financial and related institutions, and two, outstanding negotiations for the period 2014 to 2017. With respect to the remittances, this matter has since been settled with financing from the government. The negotiations for the period 2014 to 2017 is currently being addressed by the Chief Personnel Officer.
Madam President, can the Minister indicate when or does he anticipate early and speedy settlement of the negotiations for a new collective agreement between parties for the period 2014 to 2017?
Minister.
Madam President, I cannot indicate the timing. Obviously, it will depend on the attitude and the positioning of both parties, which is the representative body for the workers at MTS, the CPO, and by extension, the management of the MTS company.
Senator Mark.
Madam President, can the Minister indicate whether the government is committed to a speedy settlement through the CPO and the Minister of Finance on this outstanding collective agreement between parties?
Minister.
The government is committed to a speedy settlement of the issues, but all that will depend on what transpires around the negotiation table between the side of the company, which includes the CPO and the management, and the side of the company, the workers' representative trade union. It is a negotiation, no different to Methanex and the NGC. Let the negotiation take its course. We cannot negotiate here in the Parliament.
Senator Mark.
Madam President, can the Minister share with this Honourable Senate the critical outstanding matters between the parties at this time? We are not negotiating. We are just asking whether you can share with this Honourable Senate the outstanding items or matters between the parties.
Oh, Senator Mark, I won't allow that question. Any other question? That's it. Next question, Senator Obika.
Thank you, Madam President. Question number 146 to the Minister of Sport and Affairs.
Leader of Government Business.
Thank you very much, Madam President, once again. The Sports Company of Trinidad and Tobago is responsible for the construction, maintenance, and management of the country's major sporting facilities. The Point Fortin region, as Senator Obika will be quite aware of, is well known for its sporting excellence and has produced its fair share of international sporting personalities. To encourage the development of sporting talent and better serve the residents of Point Fortin and environs, the government developed a plan for the upgrade of the Mahaika Oval Point Fortin, consistent with international standards. In January 2018, Cabinet agreed that the government, through the Ministry of Sport and Youth Affairs, enter into a contract with UDICOT for the implementation of a project for the upgrade of the Mahaika Oval. Sport will provide the monitoring and oversight services for the project. Construction of the Mahaika Sporting Complex commenced in August 2018 and included a new main pavilion with a seating capacity of approximately 795 persons and 3 levels, serviced by an elevator and external staircase. The pavilion will also include ground floor, change rooms, public washrooms, electrical rooms, administration storage rooms, physio sick bay rooms, first aid rooms, and 30 parking spaces. First floor, meeting rooms, offices, reception areas, first aid room, storage room, concession booths, etc. Second floor, media center, VIP lounge, washroom, kitchen, electrical rooms. To date, Madam President, a total of 9 contractors have worked on the upgrade of Point 14. They are as follows. Traffic Fix, General Contractors Limited, preliminary works. SMH General Contractors Limited, substructure and foundation. 3, York Structures Limited, structural steel. 4, LCB Contractors Limited, concrete work, external works, roofing and finishes. 5, MMAL Construction Limited, seating. 6, CAG 2K Industrial Services Limited, plumbing, tanks and sewer. 7, Inelectra Limited, electrical. 8, Peaks Technology, air conditioning. And 9, RBP Lift Limited for elevators. To answer the question, Roman 2, the amount spent on the project as of April 30th is $17,378,408.97, VAT exclusive. The remaining cost of the project is $28,823,500.17, VAT exclusive, bringing a total cost of approximately $46.2 million. The expected date of completion, Senator Obika, of this project is right around the corner, October 31st, 2020.
Senator Obika.
Madam President, given the significant cost overruns as the budgeted allocation at the beginning of this project was $15 million, can the Minister indicate what are the reasons for the increase in cost in this project?
Minister.
I wasn't aware. I saw no reference to what was the initial cost. The answer that was prepared here is how much money was spent as of 30th of April 2020 and what is the remaining cost of the project. But from all indication, it is value for money because it is an elaborate construction site, bringing full international standard facilities to the people of Point 14 and environment. And I'm sure you'll be glad for that.
Senator Obika.
Thanks, Madam President. Of course, anything for Point 14 I'm glad for. However, the question still stands. What would have been, then I would rephrase it, what would have been the original cost of the project, given the initial allocation was in fact $15 million?
No, Senator Obika, I won't allow that question. Next question, Senator Obika.
The question, Madam President, is what is the initial cost of Mahika Oval's construction?
And you just repeated it, and I'm not allowing that question based on the question that has been asked. Any further supplemental?
If those questions don't qualify, no. Madam President, I don't have any further supplemental questions.
Congratulate the government for its good work.
Next question.
I would challenge the government on the increase.
Next question, Senator Obika.
Yes, Madam President. They will answer to the increasing cost of projects.
Senator Obika.
Question number 148 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Madam President. Madam President, the government is concentrating on the San Fernando to Point 14 segment of the project at this time. The COVID-19 lockdown caused a delay in the progress of the project, which was expected to be completed by January 2021. With the resumption of work and providing that we have fair weather and no further unseen delays, it is expected that this segment will be completed by the first quarter of 2021. I thank you.
Senator Obika.
Madam President, can the Honourable Minister indicate if these delays have increased the cost of the project?
Minister.
Madam President, the delays were caused by the COVID-19, and at this time, I have no indication that there will be any increase in the costing of the project. Thank you.
Senator Obika.
Can the Honourable Minister give a figure as to the full cost of the project over the last 5 years?
No, Senator Obika, that question does not arise.
The final question, Madam President, is what stretch of the road do we expect to have in place before they leave office when the general election is called?
Senator Obika, that question does not arise.
Okay, well, they will have to answer to the public.
By 2030, it should be finished. 30.
Booking Standing Order 2715 as it relates to the first question, Madam.
So Standing Order 2715
Yes.
is invoked in respect of question number 96.
Motions relating to the business or sittings of the Senate and moved by a minister.
Acting Leader of Government Business.
President, having regard to the fourth interim report of the Joint Select Committee appointed to consider and report on the Miscellaneous Provisions Local Government Reform Bill 2019, 5th Session 2019-2020, 11th Parliament, I beg to move that the committee be granted an extension to June 30th, 2020 to complete its work and submit a final report.
Honourable Senators, the question is that the Joint Select Committee appointed to consider and report on the Miscellaneous Provisions Local Government Reform Bill 2019 be granted an extension to June 30th, 2020 to complete its work and submit a final report. Those in favour say aye. Those against say no. I think the ayes have it. Acting Leader of Government Business.
President, having regard to the second interim report of the Joint Select Committee appointed to consider and report on the Constitution Amendment Tobago Self-Government Bill 2018, 5th Session 2019-2020, 11th Parliament, I beg to move that the committee be granted an extension to August 31st, 2020 to complete its work and submit a final report.
Honourable Senators, the question is that the Joint Select Committee appointed to consider and report on the Constitution Amendment Tobago Self-Government Bill 2018 be granted an extension to August 31st, 2020 to complete its work and submit a final report. Those in favour say aye. Those against say no. I think the ayes have it.
Public Business, Government Business Bills, second reading.
Honourable Senators, before I call on the Attorney General, permit me to make a few observations about some tendencies that seem to be emerging in the course of members contributing to debates in this chamber. The first tendency is that of reading. I will remind members of the provisions of Standing Order 4211, and I will remind members that contributions are not to be read. I don't know if the introduction of the podium is lending to that tendency, but I would ask members to please observe the standing order. And the second tendency is that I'm noticing that reference is being made to previous rulings by the presiding officer as to relevance or otherwise, and members are making offhand remarks about said rulings, clearly conveying that their disapproval of such rulings. I will ask members to be reminded that such declarations are improper and can be seen as containing veiled challenges to a presiding officer's previous rulings and to the presiding officer's authority to make such rulings with respect to a member's contribution. So I'm asking members to please desist from that tendency and that method of debate. Attorney General.
Thank you, Madam President. I beg to move that a bill entitled An Act to Amend the Registrar General Act, Chapter 1903, the Registration of Deeds Act, Chapter 1906, the Conveyancing and Law and Property Act, Chapter 5601, the Real Property Act, Chapter 5602, the Stamp Duty Act, Chapter 7601, and the Registration of Title to Land Act 2000 be now read a second time. Madam President, the bill before us today is one of the most important pieces of law that the country will have under consideration. The parliamentary record for this session, the 11th Republican Parliament, will demonstrate that this bill has had previous incarnations beginning in the year 2017. We have been at the amendments to this package of law 2017, 2018, 2019, and now 2020. I say that because in looking at the amendments that this bill proposes to these several pieces of law, we have had deep stakeholder contribution and consultation for nearly 4 years ongoing. In particular, the consultative process has been deepest with the Law Association. The correspondence passing between the Attorney General's office and the Law Association is on record beginning in 2017. In 2017, straight up to today's date, the Law Association has been in deep consultation. As a result of the consultation with the Law Association in particular, I wish to say that we propose amendments to the bill before us. We have taken the opportunity, Madam President, out of ease and convenience since last week to submit to all senators a marked up revised version of the bill. That has been submitted to opposition, independent, and government senators, and I wish to profusely thank the Law Association and its Conveyancing Committee, referred to as the C4 Committee, for their excellent work in providing responses. I wish to thank Senator Rambarat in particular, who sat with me for many, many, many hours in Zoom meetings with the Law Association for that. By way of letter dated June 2nd, 2020, that is today, the President of the Law Association has expressed his thanks for the last 2 meetings we held, Thursday, 21st May, Wednesday, 27th May, to discussions on the provisions of the bill, and he has acknowledged that there are still some issues which are of concern. He has tabled it as great concern for the conveyancing practitioners, and that he is happy that I will continue to meet with them, and he acknowledges even whilst we continue the debate on the bill scheduled for today. So we have come a very long way. I want to thank the Bankers Association, the Financial Intelligence Unit, the Chief State Solicitor's Department, members of the public, the Law Association for 4 years of work. Permit me to also now put onto the record that this bill comes alongside the Land Registration Package, the Registration of Title to Lands Act, the Land Adjudication Act, the Land Tribunal Act, the amendments to the State Suits Provision, which we did in this Parliament. And very importantly, that this bill has a proclamation clause, and this proclamation clause, which is at the very early parts of the bill, is specifically intended, and I want to give an undertaking on the record of the Parliament now, that Clause 2, which refers to the Act coming onto operation by way of proclamation, this bill will not, if it passes muster, be proclaimed as and until a very critical piece of operational machinery is installed, commissioned, and tested as working at the Registrar General's office. That is the property, business, real estate solution. By that bill operating with the technology at the Registrar General's office, this law, I'm giving the parliamentary undertaking, which is actionable, that the bill will not be proclaimed until that law is built upon the system. I can tell you that the property, business, real estate solution has been tested by the Law Association for 2 years nearly, The version 3 goes live this month of June, and it is intended to be in full operation, hopefully by September, but that is once we test it with the Law Association and therefore allow, importantly, electronic filing of everything contemplated by this bill. In other words, then, the administrative difficulties at the Registrar General's office will be put to an end by clicking the submission at your desktop in your office and submitting electronically. And that therefore takes away all of the confusion as to how the law will be operated. Permit me to jump immediately to the bill. What time is full time, Madam President?
6 minutes past 11.
Much obliged. Madam President, land is the most precious resource next to your liberty and life, and probably in front of cash. In an island like Trinidad, an island like Tobago, it is a finite resource. In our land system, we on average every year register, and I'll give you the figures for 2018 at the Land Registry. We registered in every month added together for 2018, 27,306 deeds. That is a deed of every type: a deed of release, a deed of mortgage, a deed of conveyance, a deed poll is separated out, but general other categories of deeds, 27,306. Registration of deeds is a requirement set out in our laws. Under our system of laws, we register so that your title is known to the world. We also register something else, and that is mortgage bills of sales. We take loans over cars at banks, etc., and to protect the interest in a mortgage bill of sale, the loan for a car, we register it within a short time frame. You only have 7 days to register, or else you have to go to court to get an extension of time. We registered 21,000 mortgage bills of sales within 7 days, as against 27,000 deeds. The short submission is, we register in a shorter time frame with more strictures and protect strictly a $25,000 loan on a car. But for land, which is a precious resource, save for deeds of gift and deeds of settlement, there is no requirement for registration. What does that mean? That means that fraud is rife in our country. The FIU tells us, when you look to the fraud factors, that in the year 2014, $30.1 million in fraudulent transactions in deeds. In 2019, $114.8 million in suspicious activity and completed transactions being part of that for that year. For the period 2014 to 2019, when we aggregate these things, attempted transactions, etc., Madam Speaker, you know that in the bracket of fraud, the FIU has told us in 1 year alone, you've had up to $22.5 billion of fraud. How is fraud perpetuated? Fraud is perpetuated because our system of registration right now for land ownership is spread across 3 laws. The 3 laws which require registration are the Registration of Deeds Act. That is an act of Parliament which was born in the very early part of our life. That is in the early provisions of 1976, the Registration of Deeds Act. The Real Property Act was born by Act number 20 of 1945, but it was introduced in the 1800s, the Torrens system, as we're well aware. We take those 2, we add the Registration of Title to Land Act, which was birthed in 2000. We did amendments recently. We intend to go live with that to give absolute title guarantee when we get to the PBRS system going live. We envelope those laws inside of the Conveyancing and Law and Property Act, and the Conveyancing and Law and Property Act is an Act of Parliament 18 of 1939. We, of course, pay stamp duty, and that is an Act of Parliament number 28 of 1908. Obviously, there were colonial laws that had these things. The Registrar General is the repository of these instruments, and the Registrar General operates under the Registrar General's Act, which is an Act of Parliament number 49 of 1921. In short measure, Madam President, permit me to dive directly to the bill. Number one, we seek to amend the Registrar General's Act by creating registries. We create registries to allow for, beyond what the index of registers allows right now, we want to add on to that the beneficial owner registry, the registrable documents registry, the contract for sale registry, and very importantly, a registry of trusts. Why? One of the major mechanisms for conducting fraud in this country is the use of a declared trust, where attorneys at law execute a trust, pay a stamp duty of $25 on it, register a deed in John Brown's name, whereas the trust says it's really Jane Doe. 20 years later, they roll up and unwind the trust and simply transfer the stamp duty from one instrument to the next, clean perfecting a fraud, if it is intended, without the lawyer's knowledge necessarily, a fraud upon Trinidad and Tobago. For example, a corrupt politician receiving a deed in 25 years' time where his son or daughter receives it, but as it's passed right now, it's shown in some innocuous name. That is compounded by the fact that what lawyers have engaged in, they execute a conveyance, they pay the stamp duty because there's a heavy clock for that, they sit down on the fact that there's no requirement for registration, and then they register the instrument 20 years later, pulling it out of a deed, a drawer where deeds are kept, and there's no penalty whatsoever. And that fraud is known to every single conveyancing lawyer in this country. And it is practiced in wide expanse, not by way of breach of the law, because there's no law to say that they are breaking, but by way of avoidance. Because the client simply legitimately has a proper lawyer acting, dismisses the lawyer and says, look, give me my deed. Thank you, I pay you for your services. The lawyer says, look, I didn't register the deed yet. The client says, that's okay. The client sits with that deed in a drawer for 20 years, hiding behind the fact that the law of equity prevails and that they are the bona fide value purchaser that cannot be put out of the transaction. Well, today is the day that that bacchanal and fraud in Trinidad and Tobago comes to the floor to be stopped. Now, I say this bearing in mind that I have practiced in conveyancing and mortgaging and worked for almost the entire banking sector since I qualified in 1996. I have deep conveyancing and mortgaging practice, deep corporate law practice, and if you notice, every piece of law that has come from the Attorney General's office in this session has been disclose beneficial ownership in companies, follow the money transactions, income tax amendments, and today we add on to demonetization, closing the abuse of trusts, closing the system where registration is not a requirement of law. Now, is conveyancing a simple practice? No, it's not. What we propose here, put in simple terms, number one, we create the registries as we make the amendments to the Registration of Deeds Act. Number two, we allow for those registries to be public as to one part and private as to another. In the deed of trusts area, it is a private register. We only allow for those private registers to be searched in the context of law enforcement. The Financial Intelligence Unit, the Trinidad and Tobago Police Service, the Board of Inland Revenue, or by way of an order of court. And you will see that at Clause 3. We then, Madam Speaker, Madam President, define a trust for the first time as an express trust, not an implied trust, not a constructive trust, only trusts that treat with land. If there's an express trust, knowing that there's an abuse of that system right now, we allow for that to be registered in a closed register. We, for the first time, reduce the fees for late registration, in particular for deeds of gift and deeds of settlement, because there is a requirement in Section 18 of the Registration of Deeds Act that deeds of gift and deeds of settlement must be registered within 12 months. We don't do it for any other type of deed, only gifts and settlement. We're reducing that now from an arbitrary up to a high of $2,000 pursuant to the RG to just $200. Madam Speaker, this law proposes that we disapply the law to public bodies. As you'll see in the amendments that we intend to move, we say that public bodies, because we will perfect the public disposal of land law by way of an amendment, hopefully by next week, public bodies are set aside from this transaction because the Auditor General operates, the Cabinet operates, and the Public Procurement Regulator operates. Madam President, what we do is we build a concept of a registrable instrument. A registrable instrument, a registrable document, is everything that treats with the conveyance of land. If there's going to be a transfer of land in any form or fashion, by way of a lease that is over 3 years, by way of a deed of conveyance, etc., it's going to be a registrable document. But we do not include in that definition a contract or any other document that may be accepted. Why? Because we don't want contracts to be in a cycle of a contract being filed for a contract. And I'll explain that when we get to the requirement for contracts. Very importantly, we say specifically, by way of a proposed amendment, Madam Speaker, Madam President, we are not coinciding equity and law. We are preserving the fact that when you execute your deed, that the equitable interest principles prevail. In other words, then your title passes on execution exactly the way it does in practice right now. We make that clear by an amendment in clause to Section 3 of the Registration of Deeds Act, and we specifically propose to amend to include a concept of feeding the title. We take Section 32A of the registration process where a deed of mortgage may be registered after a conveyance. We keep Section 32A of the Conveyancing and Law and Property Act so that when you register the mortgage after the conveyance, even though it should have been done the other way around, you feed the title and you cure the title. Madam President, basically we say in subparagraph F, we're harmonizing the way in which you execute deeds inside and outside of Trinidad and Tobago. And these amendments to the registration of deed process, we lift the exact formula that we use in the Real Property Act. So instead of having two systems that are confusing, common law and real property, we make sure the method of execution, mode of execution in and out of Trinidad is harmonized. Madam President, did you say 6 minutes past? God help me. Madam President, we ask for the inclusion of a contract for sale or other disposition of land. What we do here, we took on board suggestions coming from the Law Association. We have removed all of the aspects of the bill where the Registrar General could have exercised a discretion. The Registrar General has an obligation simply to receive a contract for sale, receive a notice of termination, receive a notice that they don't agree. And what we're doing here is we are protecting purchasers. The rule in law is caveat emptor, buyer beware. But what happens in our system is buyers are never told the whole truth. And in that particular system, we are saying if you are going to have a conveyance, if you're going to dispose of land, put your contract for sale on the record so that the whole world knows who's treating with land. I polled a number of attorneys at law in conveyancing. I can tell you I have only had 3 matters in 24 years go to court where a deposit was lost. Most lawyers will tell you the vast majority of transactions are ended with peace. What we do in this particular position is we put buyers aware of the situation, and there is a methodology, because the small cases where people don't agree, they inevitably end up in court asking for specific performance, and then you're put out of the transaction. This protects poor people in particular who don't have the wherewithal to know what's going on in a transaction. It's tied into other aspects of the bill where for the first time we are putting an obligation on attorneys at law. Number 1, they must be FIU registered. Number 2, they must have practicing certificates. Number 3, in this bill, we tell attorneys at law, you must certify in writing to your client what the transaction involves. No more will there be a poor little old lady coming to your door to say, I didn't understand what the lawyer said. No more will there be a lawyer at the mercy of an untruthful client saying the lawyer didn't explain it to me. And those matters end up in court and before the disciplinary committee on a constant basis. That comes to an end under this law. Very importantly, we say all registrable documents under Part 4, the new 15D onward, all registrable documents are to be registered. But what we do is we disapply the law. We do not include in the registrable factor within 12 months anything which is bona fide. Number one, deeds of release, deed of rectification, deeds of confirmation, substitution, surrender, exchange, mortgage, debenture, partition, assurance, amalgamation, commercial leases, residential leases, deeds of agreement for sale of land, deeds under court order, family settlement. And we specifically say they are not required to have a contract before the instrument. So what we only hold on to is a contract with respect of a disposition of land. You're selling your land, put your contract on record. We only say that the contract must come on record when it is fully executed. We therefore preserve the right to have it delivered in escrow, out of escrow. We preserve the facility to have multiple contracts. We preserve the ability to have part performance in law that's specifically set out here. And we do not say anything other than before you register your conveyance or your disposition, register your contract. In other words, then, the two can actually happen almost simultaneously. It allows for the flexibility of contract. Madam President, we say, because we recognize that there are loads of reasons why somebody may not be able to register a deed within 12 months. For instance, valuations division at stamp duty is not yet ready. Somebody may have had some difficulty in getting instructions. They may not have the money for the stamp duty. What we say is when you have fully executed the deed, file a notice to say you have fully executed. We allow in this law applications for extension of time for the notice of execution, for the contract, and for the conveyance. We allow in this law for the conveyance, the assurance, the disposition of land to be extended up to 24 months. No penalty up to 24 months. After 2 years, knock on the door of the court and ask for permission to register late. Let me remind you why I mentioned mortgage bills of sales. To protect a $10,000 loan secured by way of a car being used as collateral in a mortgage bill of sale, you have 7 days to do that. And you find yourself in court, lawyers go to court to extend that mortgage bill of sale life. Why can't you do it for land worth billions of dollars? So we preserve due process routes and requirements. Madam Speaker, Madam President, we put in a very important new Part 5, which is the duty of attorneys at law to inform clients of obligations. This is to protect consumers and protect the legal fraternity at the same time. But stick a pin. Every step of the transaction that we are asking lawyers to now add into this thing is done by way of forms. We have precedented the forms. You don't have to make it up as you go. There's a form that you fill out. Now, Madam Speaker, Madam President, the Real Property Act brought into effect in this country in the 1800s, when you look at the iterations of the law prior to that. That law, title does not pass until the memorial is registered on the certificate of title. In other words, then, 20% of Trinidad and Tobago's land title is secured by way of no transactions happening until you register the instrument. We are not doing that. We are preserving the fact that your title passes on execution, but we're requiring you to register the instrument exactly as you would for a mortgage bill of sale. You must register the instrument. Madam President, we very importantly in the new 15I insert the curing of title by way of registration of a deed of release after a conveyance. Obviously, you can't convey something that you don't have. You don't have it if there's a mortgage, because part of the ownership is owned by the bank, part of it is owned by you. So you have to have a release. We insert a new subclause 10, you'll see in the marked up provisions for senators, where we preserve the fact that the title is cured when the release is executed when the release is registered after the conveyance. Why? Because we're preserving the rule of equity. Nowhere in this law are we disturbing the law of equity.
Attorney General, you have 5 minutes.
Much obliged, Madam President. Madam President, we have taken on board recommendations from the Law Association. We remove the use of penalties which look exactly like the Stamp Duty Act under the new Part 7 of the Registration of Deed Cycle. And what we do, where the lawyer is negligent, where the lawyer has failed after a whole 24 months to do what the lawyer should do, 2 years, no excuse. The lawyer's maximum exposure is to lose half of what the scale of fees that the lawyer could charge would be. That is not unreasonable, Madam Speaker, Madam President. We also allow for this situation where a client can fire a lawyer. The transaction may be completed, the deed is not registered, it's fully executed. In those circumstances, we put the obligation upon the purchaser, the legal personal representative, whomever it may be, to take the obligation. And we have again reduced the prospect of penalties, and we have put it down to a minimum of $5,000, Madam President. After they had the same opportunity to extend, to apply, to be aware, we are protecting all sides of the transaction, Madam President. Madam President, we also, very importantly, in the rest of the law, simply, apart from precedenting out all the forms, so that there can be no exorbitant charge, lawyers only need to fill out forms. We allow for the reciprocity where the Registrar General will acknowledge receipt, serve the receipt. Anything where there's disagreement, all parties are made aware. And then what we do in the rest of the bill is we copy and paste the formula from the Registration of Deeds Act into the Real Property Act. We harmonize the Conveyancing and Law and Property Act. And critically, we remove an insanity in law. Right now, the avoidance of stamp duty, worse yet, the evasion of stamp duty is a $400 fine. We amend that today to put criminal sanction proportionate to the abuse of stamp duty. Now, Madam President, this law is not like any other law. There are views for or against. The purpose today is very narrow. Register your deed. Why are you sitting down on an unregistered deed inside of a drawer? Why? If you have a reason, tell the registrar. If you have a reason, tell the court. Get permission. You have no excuse, lawfully or within reason, to sit down on an unregistered deed, except that you are intent on fraud. Let me repeat that. You cannot be sitting down on an unregistered deed. Number two, what is wrong with disclosing your contract? Is there some difficulty as to a small aspect of contracts where there may be dispute? Yes. Go to the court, you'll see the High Court actions for specific performance or to set aside a deed that went to somebody else because somebody else had a prior interest. Those matters will go to court anyway. What we're doing now is we're feeding the concept of caveat emptor, buyer beware. We are protecting people and lawyers at the same time. I want to say this most respectfully. When the 1986 reforms were coming into effect, the Law Association kicked up storm and dance. Wiley wrote a whole book. All of us at law school read it. Never once came into law. When we were amending the Companies Act, song and dance, the system will die, continuance will kill the profession. That came and went. When we were changing to the civil proceedings rules, the profession will end. It will never happen. Today, matters finish within 1 year. When we did the beneficial ownership law the other day, the non-profit organizations law the other day, the anti-terrorism law the other day, the criminal division law the other day, the Law Association objected to all of it in certain aspects, not them alone, but society as well. All of that has come and gone. The same criminal division that they objected to is the salvation for this country in electronic filing, virtual appearances. And so Trinidad and Tobago, do not be afraid to make amendments to eliminate fraud. This is about money laundering. And Madam President, I look forward to the debate before us as I've run out of time, and I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Registrar General Act, Chapter 1903, the Registration of Deeds Act, Chapter 1906, the Conveyancing and Law of Property Act, Chapter 5601, the Real Property Act, Chapter 5602, the Stamp Duty Act, Chapter 7601, and the Registration of Title to Land Act, 2000, be now read a second time. Senator Mark.
Thank you, Madam President. Madam President, I'm very pleased to make my contribution on this very important miscellaneous provisions bill of 2020, which seeks to amend a number of very critical pieces of legislation, including the Registrar General's office, falling under the Registrar General's Act, the Registration of Deeds Act, Conveyancing and Law of Property, Real Property, Stamp Duty, and the Registration of Title to Land Act. Now, Madam President, no one can argue the need to curb and to get at the root of fraud in transactions that may be taking place in land, and to deal with the whole issue of money laundering that would flow from those activities. But Madam President, because this bill constitutes a fundamental and radical departure from established practice and what has been referred to as common law in the field of conveyancing and property law, I believe it's very important that the government, even though the AG has referred to consultation and it being had on a large or wide scale, we are yet to see, Madam President, a green paper on this very important subject matter. We have not seen any legal opinion that would indicate how this will impact on property rights and property relationships between vendor, purchasers, and, of course, the regulator. So it would have been useful and very important in a society that has respect for democratic norms and values, when fundamental changes are being made to land matters, that it be subject to large-scale consultation with the population. And Madam President, I believe that even though the Attorney General has indicated that there has been some correspondence from the President of the Law Association on this matter, it is my considered view that there are fundamental differences still existing between the Law Association of Trinidad and Tobago and the government of Trinidad and Tobago as it relates to what measures we are debating today. And therefore, I would like to urge the Attorney General that this matter ought to be referred properly to a joint select committee so that this could be aired and addressed properly and not be rushed as the government is attempting to do. Because, Madam President, there are several important pieces of legislation that are involved and that will impact, as I said, how business is conducted in land matters. Now, I know that the fundamental question of registration, of agreement of sale or sales of agreements for the purchase of land and other mortgages, that remains a touchy subject. And for the Attorney General to say that he's going to pass the legislation but will not proclaim it, I think represent a betrayal of what I understand to be a commitment given by the government to the Law Association that they will allow this matter to be referred to a select committee or a joint select committee. I just put that based on the information that has reached me on this very important piece of legislation that we are debating today. Now, Madam President, because of the complexity and the number of pieces of legislation that is involved in this bill that is before us, I can only focus on maybe one or two pieces of legislation that are being amended in this Miscellaneous Provisions Act of 2020 that we are debating. And the first area, Madam President, I would like to pay attention to is the Registrar General's Act of 1921. Now, Madam President, I find it amazing that the government currently has under the Registrar General Office 4 indexes. And in the bill that was tabled recently in the Senate, it was increased to 7. And with the proposed changes, Madam President, as circulated, it has now gone to 8. Now, could you imagine, Madam President, the Registrar General's Office having the capacity to deal with 8 registries, 8 of them, with all the challenges that the current Registrar General's Office has to deal with? So I find it amazing, stunning that this is being proposed. Madam President, what is even more amazing in the legislation, and I want to thank the Attorney General for indicating about the fraud, about the money laundering, about the denial of stamp duties to the Treasury by elements that are involved in transactions involving deeds of trust. And you know, it is obviously concerning that we were told by the Attorney General about these developments and these transactions, and why would you sit on a registration of deed matter? Why wouldn't you register it? You stay for years because you are intent on committing fraud or words to that effect. Madam President, I want to ask the Attorney General, through you, with the 8 new indexes that is being proposed in the legislation, one specifically dealing with the index of trust, why would the Attorney General want that index of trust not to be exposed to the public? Madam President, The Attorney General has made a case for that index of trust to remain open to the public. And we are objecting very strenuously and very firmly against any decision through legislation, Madam President, to deny the public access to deeds of trust. I think deeds of trust should be open and accessible to the public of Trinidad and Tobago. And I call on the Attorney General to reconsider that change that is being proposed in the legislation, Madam President. I don't think, Attorney General, Madam President, I must tell you, I have done some research on this matter. I have looked at international standards, international treaties that treats with the issue of access to information. And Madam President, access to information has been deemed by international standards and treaties and declarations as a fundamental human right. That is why, Madam President, in our Constitution, there is a provision that deals with the freedom of expression and the freedom of thought. And in all the international standards, declarations, and treaties, it has been made abundantly clear that that provision of freedom of expression and freedom of thought is equivalent, Madam President, to your freedom as a citizen to access information. And therefore, I believe that the Attorney General needs to revisit that question. This collides with sections 4 and 5 of our Constitution. You cannot deny the citizens, Madam President, access to information. Madam President, may I also ask you to consider where in the current Registrar General Act, I am talking about clauses 5 and 6, you and I and members of the public can now go to the Registrar General's office and with the payment of a fee as prescribed under 5 and 6 in the schedule, we can access, Madam President, any deed of trust. Why is the Attorney General in 2020, after almost 100 years, Madam President, may I advise again that this act called the Registrar General Act came into effect and into existence in 1921, almost 100 years ago, and our people from that period to now as we speak have access to deeds of trust. So almost for 100 years, upon the payment of a fee, we could go to the Registrar General's office and have access to deeds, trust deeds, or deeds of trust. But we are being told today, Madam President, that the public, under the amendment, Madam President, and the amendment is very clear. The amendment says, Madam President, in clause 3 of the legislation, that the Registrar General shall, in addition to the indexes under subsection 1, which is now 8, Madam President, keep a separate index for all instruments of trust registered under the Registration of Deeds Act, which shall not be open to the public and which may only be accessed by the following individuals, Madam President: the Director of the Financial Intelligence Unit, a member of the Police Service of the rank of Superintendent, the Chairman of the Board of Inland Revenue, Madam President, as well as an order of a court. Why would we want to deny the people of Trinidad and Tobago access to the trust of an individual? Why would we want to do that? When over 100 years, 1921, when this act came into being, we could have paid a fee and access a trust deed, because that would assist our country in dealing with transparency and accountability and fraud and corruption. What does the government have to hide? Why is the government seeking to deny access to the population of our country to this important, fundamental, democratic right, the access to information? Why? That is the oxygen of democracy, information. Why do you want to deny us that, Madam President? Madam President, I am very disturbed about this development, and I am calling on the government through the Attorney General to back back on this decision. Madam President, I want to join with the Attorney General on this matter, because I agree with the Attorney General that there are people in this society who are using trust deeds in order to deny the people of this country their just dues in terms of stamp duties. And the Attorney General of our country, who was a former attorney in private practice, would be familiar with this particular practice. I do not want to expose anybody here today, but I can tell you I have evidence of this practice involving high-ranking people in this society, Madam President, who have used the trust deed as a method, as a technique, in order to deny the citizens, Madam President, the right of proper stamp duty. And that is why, Madam President, when I refer to stamp duty, we are amending the Stamp Duty Act in order to make it more expensive for those persons who engage in fraudulent activities, who falsify documents in an effort, Madam President, not to pay taxes to this country. Madam President, that is a very serious matter. Madam President, I am aware of a situation, Madam President, and Madam President, I will not call names, but I have the names of these people where a fraudulent act was committed against the people of Trinidad and Tobago, using the same stamp duty and using the deed of trust. Madam President, land was transferred among the 3 lots located at an unknown number on Picton Street in Port of Spain from a company. I researched the company. The name of the company is Canon. And Madam President, this company transferred 3 lots of land, Canon, to a company called Belgrave Properties. Madam President, would you believe that Canon bought these 3 lots of lands from Century Janitorial Services Limited for $3 million, for $3 million, Madam President. Janitorial Services bought it then for 1-point-something million. And they bought that for $3 million. Madam President, would you believe that this same Canon company sold to themselves, they create a company called Belgrave Properties, and they sold the land 12 years later. They bought it in 1999, 2000, Madam President. And in 2012, they created a company called Belgrave Properties. And you know what they did, Madam President? They sold themselves the 3 lots of land that they bought for $3 million. You know how much, madam? For $1.75 million. This company called Canon sold to itself, created a company called Belgrave Properties for $3 million and sold it to Belgrave for $1.7 million. That is what the AG is talking about. Because by doing that, they have denied the public and the citizens of this country property stamp duties, Madam President. That property that they sold for $1.7 million was valued at over $12 million. Over $12 million. And they sold that property. And you know who bought that property, Madam President? You know who bought that property for $1.75 million? Another high-ranking individual in this government. Madam President, I am not telling tales out of school. You can go in the registry right now and see who are the new owners of Belgrave Properties. And you have you have over 60 apartments being constructed right now on Picton Street. And Madam President, we are being told if we did not have access to the registry to get the trust deeds, how would I be able to tell you this today, Madam President? That there are people who are using the trust deed in an effort to deny the country revenue, to engage in fraud, to engage in money laundering in this country. And the Attorney General should be investigating. In fact, this is a matter for the police. The police should be involved in this matter because the Attorney General is aware of the individuals who are involved in this transaction.
Tamar, I don't think that you can say that. I think you have to withdraw that statement. And yes,
I'm sorry, I apologize. What I can tell you, Madam President, is that it is amazing how these things are taking place in our country. And we have an Attorney General who I can only say is not au courant with what is going on here. Or either he is aware of what is going on here. And I want to know, Madam President, is the government seeking to cover up? Is the government seeking to deny? Is the government attempting to hide those elements that are using trust deeds in an effort to deny us stamp duties? Is that the objective why the government is saying we must not have any access to trust deeds in this country? Madam President, it goes on, Madam President, and I believe, Madam President, that the Minister of Finance of this country needs to come and tell us whether he's aware of a company called Belgrave Properties. We would like the Minister of Finance to tell us this. We would like the Minister of Finance to tell this country, Madam President, and this Senate, whether he bought a property for $1.7 million when that property was worth $12 million and denied the country endless stamp duties. These are matters that we want to get clarified. I cast no aspersions. All I'm concerned about is like the Attorney General. We want to root out fraud. We want to root out money laundering. We want to get our just dues that are owed to the people of Trinidad and Tobago. And we need to get these people who are involved fully exposed. And the police, the Commissioner of Police, should be involved in this land fraud transaction where we have been denied millions of dollars, if not hundreds of thousands of dollars in stamp duties, Madam President. Madam President, you know, they always talk about the Mohicans, the last of the Mohicans. Madam President, this question about the index of trust, we have to be very clear on what we are doing. Because this thing is the tie, Madam President, to a situation, another example, and again, Madam President, if I did not have access as a citizen of this country to go to the Registrar General's office to access these trust deeds, how would I be able to share this information with you today? And you are telling me through the Attorney General in 2020, after 100 years, that you are going to deny me and the 1.4 million people of this country access to trust deeds, when you know, Madam President, that fraud is being committed in this country and all kind of money laundering is taking place? This is wrong, Madam President. Madam President.
Senator Mark, you have 5 more minutes.
Madam President, I'm closing because, as I said, I can't deal with everything today. But I'm zeroing on something that touches the hearts and minds and soul of the people. Because right now we don't have money. We are crying out for money and finance and revenues. And, Madam President, there are people who are cheating, thieving, denying, undermining our stream of income. Madam President, let me give you another classic in closing. You talk about the Mohican. I want to deal with the Mohicans. Madam President, there's a building rented by the Defense Force for 3 years. That building, Madam President, cost the taxpayers close to $600,000 a month in this country. I have the name of the owner. I wouldn't call the owner. But it was sold, Madam President, a short while ago. But you know, it was sold to another company that is well known in the prisons business, transporting prisoners. They transferred that property, Madam President. You know how, Madam President? Through a deed of trust. Through a deed of trust, it went to that person, company. And you know what happened? They pay stamp duties. Or if they paid stamp duty, it was next to nothing. Because just like how Canaan transferred to Belgrave, and they're paying nothing, it's the same way this company transferred to another company, and they're paying no stamp duties, or they pay next to nothing. But, Madam President, you are coming here today as the Attorney General, who is supposed to be the guardian of the public interest, and telling us that my fundamental human rights, which is enshrined in the Constitution under the section that deals with freedom of expression and thought, that I don't have any right from today, when this bill is passed, to access information under trust through the Registrar General's office. So why are you creating a secret society? So, Madam President, only a few people who are engaged in this dirty kind of transaction, they are now going to be given protection by the Parliament of this country, because the Parliament of this country is going to pass legislation that will deny even lawyers, even the Attorney General, when he goes back into private practice shortly, will not be able to access deeds of trust because he's a member of the public. Only 4 individuals, Madam President, including the court, would have that right. That is wrong. And, Madam President, I call on the Attorney General not to proceed with this amendment that is going to deny the public access to information on deeds of trust. It must remain as it is, open and available to the public. I have many more things to say, but I'm awaiting the campaign to deal with this matter. I have names to call, but I know, Madam President, you will not permit me to call names in this Parliament. I can do it on the public platform, but it is too much for the poor people of this country. And the AG must take action. The Commissioner of Police must take action. And the Attorney General must withdraw that offensive, obnoxious, insulting provision or clause that is going to deny the public access to information, which is my fundamental human right, Madam President. Madam President, I can say much more, but I know that my time is up. I will get an opportunity to speak on another matter very shortly. And at this time, I want to thank you for giving me the opportunity to deal with this matter. Thank you very much, Madam President.
Senator Sipasad.
Madam President, thank you for the opportunity to contribute on the bill, an act to amend the Registrar General's Act, the Registrations of Deeds Act, the Conveyancing and Law of Property Act, the Real Property Act, the Stamp Duty Act, and the Registration of Title to Land Act 20,000. Madam President, the explanatory notes of the bill address the issues with respect to prevent fraudulent land transactions, 2, make legal arrangements and the beneficial ownership with respect to land or property transparent, and 3, comply with international requirements under the Recommendation 25 and Immediate Outcomes 5 of the Financial Taskforce recommendations. While I understand the amendments are critical in order to strengthen the existing laws as they relate to property transactions, I agree with the need for, 1, compliance with the international requirements under Recommendation 25 and Immediate Outcomes 5 of the Financial Taskforce recommendations as shown in Clause 3.1 of the bill, that is the amendment to the Registrar General's Act. The implementation of the closed index of instruments of express trust will ensure compliance with these international requirements. The index is expected to have a high degree of confidentiality, which I support, since it will only be accessible by the Financial Intelligence Unit, the Fraud Investigations Division of the Police Service, the Board of Inland Revenue, and the court. And the index will permit the analysis, investigation, and the prosecution of financial crimes. 2, Clause 4 of the bill deals with the scrutiny by the Registrar General's Department of persons who can present deeds and other documents for registration. These persons have to be authorized by an attorney at law who is registered with the Financial Intelligence Unit and has a valid practicing certificate issued under Section 23 of the Legal Professions Act. Madam President, this measure is essential to mitigate fraud in land matters. Madam President, I now come to the office of the Registrar General's Department. From my research, I understand that the primary function of the Registrar General's Department is to maintain the records of the registry and to operate 2 systems. 1, deeds registered under Real Properties Ordinance, the RPO, and 2, deeds registered under the common law. The amendments proposed in the bill require the role of the Registrar General's Department to be expanded, and they'll have some quasi-judicial authority. If this expanded role is incorrectly or negligently played by the Registrar General or not played at all, parties can potentially suffer losses. So my concern is whether the Registrar General is adequately staffed and resourced to facilitate this requirement, which may also include liabilities for losses incurred by the parties. I know that the Registrar General's Department is presently woefully under-resourced. Most of the staff are on short-term contracts. and they are not even adequately trained to deal with the current registration system. So they can hardly cope with the current demands asked of them. Madam President, what will be the situation when the department is required to deal with a large volume of conveyancing documents, all of which must be registered, I agree, electronically, but in a timely manner, as provided in Clause 15 of the bill? Now, I understand the electronic filing system, which is the Property Real Estate Business Solution, is going to be implemented and is not in place. But however, people still need to be trained, be properly trained, to deal with the electronically filed documents. With respect to Tobago, I'm not aware of any provisions to address the existing difficulties with property title searches in Tobago. This bill, in my opinion, will further complicate conveyancing in Tobago. I hope that consideration will be given to deal with the peculiar issues with conveyancing matters. Madam President, why not assist those who own land but have no legal title to rectify this unsatisfactory situation instead of complicating it? Now, I've had some experience in some of these matters, and in my view, the process proposed by the amendments in this bill will result in making the process for buying, selling, and leasing properties more complex, involve a rigid and longer process. However, in many common law jurisdictions that have progressively simplified and modernized land law, countries such as Jamaica, Canada, England, and Ireland. So the bill contemplates title passing to the new owner only upon registration of the deed and not when the purchase price is received by the vendor. Many impediments can occur between the receipt of the purchase price and the final registration. For example, you have frequent delays by the Board of Inland Revenue in accepting the purchase price as the market value of the property, and that is used to calculate stamp duty, or delay in the final registration of the deed by the Registrar General because she requires some information or explanation about whatever is presented to her. Now, during that time, the vendor has received the entire purchase price, which a bank may have financed. So no title to the property has been acquired by the purchaser, and by extension, the bank or financial institution. The amendments proposed will invariably result in increased costs for the sale, purchase of properties. Attorneys' fees and various disbursements will escalate because of the requirements to register and file a significant increased number of documents for the sale and purchase of property to be satisfied. This will cause hardship, particularly to those persons who wish to purchase lower and middle cost properties. Madam President, it may even result in the increase in the real estate prices under this scenario. Compulsory registration is also required for the contract for sale as well as for all variations in the terms of the contract. This is in Clause 15. And things that this covers are such as changes in the names of the parties and extensions of time to complete the transaction. So further, while parties are currently able to privately negotiate an agreement for sale of land, the bill makes it mandatory that the contract must be first prepared by an attorney at law and registered with the Registrar General's Department within a month of execution. Failing to do this, severe penalties will be imposed for non-compliance. While the Registrar General is empowered to extend the time, there will also be an additional cost. The attorney's administrative cost of doing business also will increase. They may be liable for fees and for fines under Section 3(4)(d). Insurance providers may also increase professional indemnity insurance premiums because of the additional risk now associated with conveyancing and leasing matters. Madam President, with respect to confidentiality and the need to register agreements for sale, parties, including companies, to property purchase and sale transaction may wish to keep these transactions confidential until the sale purchase is completed. Given the need for competitive advantage by businesses, unwarranted disclosure of intent can negatively impact the viability of transactions and, by extension, projects. Also, the amendments could potentially adversely affect Trinidad and Tobago's ranking in the Ease of Doing Business Index. We're currently ranked 105 out of 190 countries. A further degradation in this index is really not a welcome change for the country, especially in these challenging economic times. When we look at anti-money laundering, counter-terrorism financing, and the FIU legislation, the proposed compulsory registration of a beneficial interest in real estate is far more reaching than any other jurisdiction to comply with FATF recommendations. The existing FIU legislation is comprehensive and is really adequate to monitor and supervise fraudulent transactions. For example, all attorneys, real estate agents, practitioners, and financial institutions have to be registered with the FIU. Who supervises these entities? If it is proven otherwise, then the legislation that really deserves to be reviewed is the FIU legislation and not the conveyancing laws per se. With regard to the constitutional right to property, in my view, the harsh provisions contained in the bill interferes with parties' freedom to engage in the sale and purchase of real estate, puts a restriction on a person, whether it's an individual or business, enjoyment of property enshrined in the Constitution, and also, Madam President, severely restricts the owner's ability to dispose of property. Given the centuries of jurisprudence and precedents which have developed our country's land laws, coupled with the possible encroachment on the constitutional right to property, I propose that the legislation be reviewed by an independent commission. Now, I'm not suggesting that this be a long, drawn-out process. This could be, you could give them a deadline of, say, June 30th. But the commission must be appropriately resourced and given the necessary time to carefully study the impact of this bill on the existing laws. The commission should be charged with making the recommendations to changes and restricted to the objectives identified in the explanatory note to the bill. Madam President, that is, address fraudulent land transactions, make legal arrangements and beneficial ownership, that is, with respect to property matters, transparent. 3, comply with international requirements under Recommendation 25 and immediate outcomes 5 of the Financial Taskforce recommendations. Thank you, Madam President.
Senator Vera.
Thank you, Madam President. Madam President, let me say that originally when this bill was brought, I was dead set against it. I had serious concerns, among other things, the additional costs that I thought the new system might impose on purchasers. Like Senator C. Prasad, was concerned about the effect public disclosure could have on commercial deals. I was very concerned about the increased risk and vulnerabilities that could be imposed on conveyancers. And I was very concerned about the heavy burden being imposed on the Registrar General's office, particularly bearing in mind that that office does not have the capabilities that the bill as originally cast would have put on the Registrar General, because under the original version, the Registrar General would have been exercising a quasi-judicial function. Happily, the Attorney General has not been tone deaf to the remonstrations and concerns raised by lawyers like myself and the Law Association. He has circulated a revised draft, which I think is a step in the right direction and has alleviated many of those concerns. So under the new version, certainly I think fraud has been effectively dealt with. That will rein in the scourge of white-collar crime that is occurring in real property transactions. It will also go a long way to countering anti-terrorism, anti-money laundering. I think that the bill does provide an antidote in those areas. The bill, I think, will also meet FATF requirements. He has reduced the crippling fines that were originally there to, I think, a reasonable level, which would be half of the prescribed fee. And he has restored the Registrar General's functions to their original scope, which is essentially about making sure that the formalities are met and towards maintaining records. So I do think we have come far. And I do think that lawyers are being effectively regulated under the FIU regulations, the FOR regulations, also in private practice, because lawyers can be sued when they are negligent or do wrong things. But this just makes the ecosystem more sufficient, because lawyers will now be further regulated in the practice of real property. Now, to be fair, the Attorney General is right. The legal profession has not always been the fastest sprinter out of the sprinter's block when it comes to the passing of laws. I recall the old Companies Ordinance. We sat on the fence for that one for many, many years for all the wrong reasons. I recall one practitioner even saying, why amend the law? It'll mean I'll have to buy some new textbooks. We were not very quick when it came to the alternate dispute resolution procedures. That has come about now, but it took some time in the making. Similarly with the civil proceedings rules, the Wolf reforms were out there earlier clock, but we seem to be going in the right direction, and then everywhere else in the Caribbean overtook us, and we were very late in accepting the CPR, and yet the CPR today is one of the best things that we have. And similarly with the Madrid Protocol, you know, it's lawyers who've been holding back on the Madrid Protocol treaty being joined. So sometimes the Attorney General does need to push and prod to get the Law Association to come along. But on this instance, I have to say that the Law Association's concerns did have validity. Now, conveyancing is not my main area of practice. I've done some conveyancing, and I've had some difficulty trying to peer into the future to see how these new amendments will impact the profession, the practice of conveyancing. I've been trying to imagine what are the potential pitfalls, whether it's against clients or against attorneys that will need to be guarded against, and whether the substantive law in relation to conveyancing is also being impacted. I have to say, I'm not quite sure where I stand there. I still have some concerns. Every agreement for sale being registered within a certain time, otherwise the extensions from the Registrar General having to be sought. The notification provisions, if an agreement ends, for example, how is that going to play out in practice? And the biggest concern for me was the question of title. When would title pass? Well, the Honorable Attorney General made clear in his contribution that title remains, it will pass on execution, but you must now register the instrument. I have to say that didn't leap at me. That was one of the things I was wrestling with, whether title was now going to pass on registration and not at execution. And how would that impact completion? Because at the end of the day, conveyancing is really about the transfer of legal title of real property from one person to another. I'm not there yet, and I'm happy that the Attorney General is still continuing discussions with the Law Association. It's important to bear in mind that when it comes to conveyancing, the legal profession has a monopoly. Conveyancing can only be done by lawyers. It will be lawyers who will operationalize this legislation. And it is lawyers who also stand most to be affected. So it's very important that in moving forward with this legislation, the Attorney General should have the imprimatur of the Law Association. Before I conclude, just to say a couple things about Senator Mark's contribution. I understand the concern about trust, but the fact is the law does allow for secret trust, usually in the context of somebody leaving under their will a secret trust for the provision of unnamed beneficiaries. That's entirely legitimate. It's not always for a sinister purpose. And because of that, I'm comfortable with just law enforcement having access to that sort of information, because people have a right to certain privacy. Also, I mean, lawyers do all the time. We come up with ways and means in which we can legitimately avoid stamp duty. So, for example, when it comes to the sale of real property, that can be also achieved by a company owning the real property. And instead of the property being sold, what you have is just a sale of shares. Tremendous saving in stamp duty. Again, legitimate. I think we all are hoping to see a modern conveyancing system, a more user-friendly conveyancing system. I think that this legislation is a step in the right direction to tackling fraud, to meeting our FATF requirements, but I'm hopeful that between now and when we conclude the debate and committee stage, that we will in fact have a document that all stakeholders are happy and comfortable with. And I thank you.
Senator Dylan Remy.
Madam President, I thank you for the opportunity to be able to contribute to this debate on the miscellaneous provisions, Registrar General, registration of deeds, conveyancing and law of property, real property, stamp duty, and registration of title to land bill 2020. In the explanatory notes, the bill purports to deal with fraud and with land dealings, making provisions for transparency in respect of legal arrangements and beneficial ownership, and meeting our international requirements under the Recommendation 25 and Immediate Outcomes 5 under the Financial Action Taskforce recommendation. Madam President, regarding the first aim of preventing fraud, the Attorney General has talked about the fact that this could be estimated to be about $22.5 billion a year in land transactions that could be related to fraudulent activity. So I am in agreement with the some of the changes that have been put in this bill to address unscrupulous practices, be it from the attorneys or from landowners or from the persons working within the Registrar General Department, all people who are wishing to deceive the public. I do agree that some of the changes that are put in this bill will address some of those issues related to fraud. It's not new, fraud is not new, and I agree that it needs a remedy. In fact, I recall that about 20 years ago, a friend of mine was involved in purchasing a piece of property from the bank in a foreclosure, an issue of foreclosure. It was supposed to be 9 acres of land. It was in Tobago. And when they checked, it was found that this land that was 9 acres and mortgaged to the bank, when the check was made, that land was sold twice. So 9 acres was mortgaged to the bank, but a 3-acre piece was already cut off and sold to somebody else, and that registration of the 3-acre piece was registered before. And as a result, this transaction had to be adjusted. So the issues related to fraud is real. And I hope that the Attorney General and the crafters of this legislation ensure, however, that the remedy that is being put in place here today is better than the disease. The reason I'm saying that, if you provide a cure that is worse and does not bring the desired outcome, then Attorney General, it would put us in a worse situation. Madam President, I'm very mindful that change is difficult. And as the Attorney General said, this change from this bill is going to be far-reaching in terms of how people currently practice in terms of dealing with lands, conveyancing, etc., registration. And a concern that I have is that there must be public education, significant public education, in terms of not just the lawyers who have been, or some of them have had an opportunity to liaise with the Attorney General's Department, those that are involved in the Law Association, but many of them right now are not involved, and they don't have any understanding of how these changes are going to affect them. So the lawyers, the land developers, and ordinary people wishing to be involved in land transactions, selling lands or purchasing lands, that a massive education project will be needed to ensure that the far-reaching effects of this bill is known. Clause 3 of the bill, subclause 2, 1A, where the Registrar General is required to keep a separate index for all instruments of trust. Like Senator Mark, I too was concerned as to why this was private or restricted, whereas the others were accessible to the public. But I am not sure if the Attorney General will probably just want to deal with that again. Does the Registrar General also have an obligation, Honorable Attorney General, to report suspicious activity? Or is it that the Registrar General, if they should just refuse registration in case they see something untoward? In other words, a piece of land here, there's already, it's registered already for sale. There's an agreement already registered, and when someone comes to register that about registration for that same piece of land, it will be seen that this is already there's a registration already there for that. Is the Registrar General only empowered to refuse that registration, or is the Registrar General also? Does the Registrar General have the power to also report to the FIU or whoever else about transactions that may be seemingly untoward? My main point, though, Madam President, is in relation to Clause 4 of the bill that amends the Registration of Deeds Act. This area, in terms of deeds, goes deep into will deeply affect what goes on in Tobago. I quote from an article taken from the website www.terrorinstitute.org. The article is entitled "The Trinidad and Tobago Experience in Land Policy Administration and Management" by one Asad Mohammed of UWI. The government of Trinidad and Tobago, I quote, has recently completed a comprehensive land use planning and administration technical assistance program funded by the IADB. This program was completed approximately a decade after another comprehensive sectoral analysis established a programmatic framework for land-related reform. And he said, the previous effort was itself conducted some 10 years earlier after major legislative review, which resulted in a comprehensive set of land legislation being passed in Parliament. So the Attorney General talks about 2007 as far as this particular suite of laws are concerned. However, this goes back to even further. And I quote again from the article, "It is fair to say that the analysis, recommendation, and programmatic framework coming from these studies have not been matched by implementation. While there remains inadequate or confused areas of analysis or policy or programmatic solution, the cause for this gap between recommendation and implementation lies mostly outside the realms of technical issues. The 1980s Comprehensive Land Law Reform Package was abandoned with some justification, but has been replaced by an ad hoc legislative agenda." And I'm asking the Attorney General, specifically as it relates to land issues in Tobago, this bill does not necessarily deal with those issues. It actually makes it more complex as far as people in Tobago are concerned. There are already issues related to not having proper land titles for many different reasons. There was an extensive discussion that was undertaken in the year 2006. There was a report by the Tobago House of Assembly where they had a special committee appointed to make recommendations for the amendment of the Real Property Ordinance and judges' guidelines with a view to finding a solution to pressing problems of land titles in Tobago. This committee was chaired by former independent Senator Dr. Eastland Mackenzie and included the well-known lawyer, Mr. now deceased Eric Taylor. And that was dated, the report was dated to the House of Assembly. It was dated August 30th, 2006. One recommendation of that committee was that they strongly recommend, I quote, that the Tobago Sub-Registry be given a home to function effectively, efficiently, and even on its own, without having to resort to Trinidad for simple services relating to land matters under the Real Property Ordinance. Madam President, some of these areas will address because the Registrar General's office in Tobago now is better positioned, it's better staffed, etc. But the issue of having to come to Trinidad to deal with deeds under the RPO remains. And there are stories of clerks who come to Trinidad, have issues when they get to the Registrar General office, have to come back to Tobago, etc., and go, Attorney General, it's the concern of persons in Tobago that these changes are going to significantly affect dealing with land issues in Tobago, and I would like to have those things considered. It was also suggested by someone that there was need to have a Registration of Titles Act to address the regulation of landholding in Tobago, and that this act would allow for adjudication of all parcels of land in Tobago, and that they would have a special court established to deal with disputes that the adjudicator cannot handle. These are things that have been discussed before. I'm not sure how relevant they are now, Attorney General, but I would like you to consider it. Madam President, while this bill considers welcome changes that will address fraudulent activities in terms of registration, not now of deeds, but registration of agreements. It deals with that lawyers must be registered with the FIU, and therefore you're having more control over what they do. I'm asking the Attorney General to please ensure that the age-old issues with land titles in Tobago are addressed and not made more complex by this new legislation. Madam President, I thank you.
Minister in the Ministry of Finance.
Madam President, thank you for allowing me to participate in this very important debate on the Act to amend the Registrar General Act and several other miscellaneous bits of legislation. Madam President, as a student of tax law ages ago, the first case that I cut my teeth on was a case called the Inland Revenue Commissioners and the Duke of Westminster, which was a 1935 case, which established a very important principle, and that is that tax law is to be strictly interpreted so that an individual ought not to be deprived of his property unless the tax authority could bring his transaction squarely within the provisions of the legislation. Because that created avenues for avoidance, a lot of tax legislation since that time have introduced anti-avoidance provisions. So we have anti-avoidance provisions in the income tax legislation, the corporation tax legislation, the petroleum taxes legislation, the VAT legislation, but there is no anti-avoidance provision in the stamp duty legislation. So the stamp duty legislation, which essentially imposes stamp duty on documents, in the absence of anti-avoidance legislation, it means that if the instrument doesn't fall squarely within the ambit of those categories of instruments brought into the charge, then no stamp duty is imposed. And that opens the door for avoidance of stamp duty. So that what we have seen is a practice developing and growing of persons advised by attorneys at law or other practitioners to enter into agreements for sale of property, but never execute those or finalize or bring to close those transactions by entering into deeds of registration. So a contract for sale of property does not have to be registered and does not attract stamp duty. A deed of transfer, deed of conveyance does. So if you enter into a transaction for a conveyance of property that you never finalize by deed, then you never are required to pay the stamp duty, and you're not breaking the stamp duty law by doing that. And so a lot of avoidance occurred as a result of this approach. So the tax authority at the moment is not allowed to look behind the document to determine as well what is the actual nature of the transaction. They have to look at what is written in the document and apply that to the stamp duty legislation. Either it's caught or it's not. Either it's at rate A or it's at rate B. So those lacunas in the stamp duty legislation have led to a lot of loss of stamp duty for the Board of Inland Revenue. So, for example, if we think back to maybe a decade ago when people were flipping properties like it was going out of style, you would have One Woodbrook Place, for example. You would enter into an agreement to purchase a unit at One Woodbrook Place and sell that within 6 months, and you keep doing that. That would have resulted not only in significant loss of stamp duty, because a lot of them may not have been translated into deeds of conveyance which attracted stamp duty, but it would also have led to a loss of income tax / corporation tax, because in that legislation, people are required to account for tax on short-term capital gains. So if you buy and sell real estate within 12 months, any gain that you make on that real estate would attract income tax or corporation tax, depending on whether you're an individual or a company. But if there's no requirement to register those transactions, and therefore they never come to the attention of the tax authority, all those taxes would be lost. It would be interesting to do an assessment of how much tax was lost during that period when we were flipping property like crazy to the Inland Revenue, to the citizens of Trinidad and Tobago because of this. This legislation that the Attorney General is seeking to pass would address that, because not only does it require you to register a contract for the sale of property, but it also requires you within 12 months to register the deed for that transfer. So it within short order brings to the attention of the tax authority what transactions have occurred in property, and therefore to allow him or her to assess whether any losses have occurred and whether they need to go after these people for short-term capital gains tax, for stamp duty. So this is a very important key in the attempt to reduce or mitigate stamp duty avoidance and other tax avoidance in this country. The provisions will certainly operate to mitigate those transactions. In considering the importance of this, one needs to recognize that Trinidad and Tobago is one of the few countries in the world that does not impose a tax on property per se. We do not really have a capital gains tax. We charge income tax on short-term capital gains, but if you own property and you sell it 13 months after you purchase it, there's absolutely no tax on that. We no longer, 8 decades ago, we had a tax on an estate duty tax, which allowed the country to recover some taxes on the death of a person. That was abolished in the 1980s or 90s, and therefore the only tax that we have in respect of property is stamp duty. A rate is applied on the transfer of property, and that rate varies depending on whether it's residential or commercial, and of course on the value of the property. But this is the only tax we have. We do not have any other taxes than property, and it is important for us to recognize that as a society seeking to develop and grow, we need to ensure that all the avenues that we have in place to collect taxes legitimately from the citizens of the country are properly collected. And this bit of legislation, as we are seeking to pass today, will allow us to do that. Perhaps of more significance than the tax issues, than the ability to mitigate the avoidance of stamp duty, is the impact that this bit of legislation will have in our fight against white-collar crime, which we are seeking in various ways to get under control. So look, for example, at the monetization exercise that we went through in December. An individual with cash that was inexplicable, he was not able to provide a legitimate explanation for it, could have gone to a businessman who can explain millions of dollars in cash and say to him, let me purchase a property from you. I will give you the cash, which I can't explain. You can explain the cash to the bank so they will accept it. And at some time in the future, we will reverse this transaction. In the absence of a requirement to register that agreement and to register the subsequent deed, that may completely escape the oversight of the authorities. A provision like this, which not only applies to future transactions, but also to transactions which occurred prior to the date of proclamation, but which have to be required, which are required to be registered within 12 months of that date, will also give the authority some measure of opportunity to look at a transaction like that, identify a transaction like that, and take the appropriate action. So not only, as I said, are we looking at tax avoidance, but we are also looking at white-collar crime, and that is only one example of the various ways in which property can be used and has been used to, in white-collar crime. Anti-terrorism, money laundering, these are all areas where property is used, because property is one of those assets that can be easily used to hide the proceeds from illegal activity. So requiring individuals and companies who get involved in land transactions to register these transactions narrows the door for that abuse. So in crafting the legislation, the Attorney General, led by, assisted by the LRC and other members of his team, have designed several solutions to track these, to treat with these issues. For example, in Clause 15, it requires all agreements for sale to be registered. This is absolutely new. Clause 4, which proposes an amendment introducing a 15A, requires the persons drafting the document to reflect all the relevant details in that document. What we have seen happen is that we have had agreements for sale that say one thing, deeds of conveyance that say something completely different, and that too allows the individuals involved in the transaction to avoid taxes. For example, there's a case that was fairly widely circulated, information on the case was fairly widely circulated a couple of years ago, where there was an agreement for sale for property of, let's say, $15 million, but before the Inland Revenue was a deed that said the value of the property was $50,000. And so the stamp duty was significantly lower than what the agreement reflected. When you now have a requirement to not only register the agreement and register the deed within short order, but also ensure consistency in the terms, that allows you to avoid situations like those that we have experienced in the past. The proposed Section 15F requires the registrar again, that the deed and the agreement be similar in terms and that they be registered within the year. Section 15F again requires the attorney at law. It puts an onus on the attorney at law who is involved in the drafting of these documents to be registered with the FIA, to be an attorney in good standing. And therefore, that closes the gap with the bit of legislation that we brought some time ago requiring attorneys at law to register with the FIA. So it is, if you have to look at the whole umbrella of legislation that the Attorney General and his team have carefully crafted to treat with white-collar crime, which is a significant scourge in Trinidad and Tobago, which is depriving the formal economy of billions of dollars, and therefore depriving the citizens of Trinidad and Tobago of the benefit of these funds. And so this is one element of that whole umbrella of legislation seeking to deal with these issues, and it is a critical part of it, and we need to add it to the toolbox so that we can complete the cycle and therefore properly deal with these issues. The proposed Section 15D requires the terms of the deed to be consistent. The proposed Section 15I is the section that requires all deeds that have been passed, that have been executed in the past, but that have not yet been registered, to be registered within 12 months of proclamation. And that's important to bring us to a level playing field, to identify any past issues so we can deal with those, and to ensure that going forward, we have a system that is consistently administered throughout. We have, excuse me, sorry. Senator Mark went on ad nauseum about this depriving people of right to information. Now, I will allow the Attorney General to deal with this more specifically, but what I will say is that this legislation is not removing any right to information that currently exists. What it is saying, that information that was not...
Minister, you have 5 more minutes.
Thank you, Madam President. Information that is not currently on the register needs to be put on the register. Certain elements of that information will be available to the public, but certain elements of the information which we recognize as private and confidential, and we are always at pains to protect people's financial information because they consider that their fundamental right to protection of that information will be only accessible to certain people who are looking to ensure that things are being properly regulated and that no criminal activity is taking place, no tax avoidance is taking place. So that is why it is restricted to the director of the FIU, to a superintendent of police who is engaged in an investigation, to the chairman of the Board of Inland Revenue, or by order of the court. We are not depriving any citizen of Trinidad and Tobago of any right of access to information which they currently have. One, because that information doesn't currently exist in a public space, and two, they therefore do not currently have any right to that information. And finally, what we are doing is increasing the penalties that currently exist in certain spheres for persons who act in a way to defraud the government of stamp duty and in other ways to enter into criminal activity or assist in the action of understating, hiding activity, and so on. So this, as I said, bit of legislation, briefly, Madam President, does, in my view, 2 things. It allows us to treat with stamp duty avoidance, which is a huge issue, and hopefully bring stamp duty receipts from the region of $400 million where it is now to much closer to $1 billion where it probably would be if we were properly declaring all of the transactions which we ought to declare. And at least as important, and probably more important, it allows us to more effectively treat with white-collar criminal activity as it involves land and trust. And so, Madam President, this bit of legislation would allow us to close that loop and allow us going forward to properly tackle white-collar crime. Madam President, I thank you very much.
Senator Sobers.
Thank you, Madam President, for recognizing me this morning to participate in the debate. Now, I would like to begin having listened to Senator, the Honorable her name escapes me.
Minister in the Ministry of Finance?
Correct, yes. I do apologize, I don't know. And she's so nice. But what I wanted to touch on is the fact that in terms of BIR, I have heard a lot of persons speaking about issues which regarding fraud that exists with respect to stamp duty and escaping stamp duty. Now, I would declare, just like Senator Vera indicated, that I am not a conveyancer by profession. I'm an attorney. I have dabbled well in terms of conveyancing, both in Trinidad and also in Guyana as well too. But my understanding with respect to fraudulent activity related to stamp duty and BIR is really when it comes to the production of the valuation documentation that accompanies the deed. So I listened and I tried to follow where some level of fraudulent activity would take place with respect to the non-registration of the sales agreements. And I know for a fact that in some instances what occurs is that when the sale agreement is actually prepared, let's say the actual agreed purchase price for the property may be $5 million. The agreement would reflect a figure of about $3 million in an attempt to escape stamp duty penalties, and then the extra $2 million may be paid on the side. So that even the deed itself, when it is presented to stamp duty for BIR purposes, for the calculation of stamp duty, there's a loophole that exists there as well too. So when I looked at the bill and I contemplated whether or not it would treat with some of these issues related to stamp duty, I thought to myself that in terms of that aspect of things, in terms of persons presenting documentation to stamp duty, to BIR for it to be stamped, it does not, as it pertains to the valuation itself, the most that would occur if the BIR has a question as it relates to the value of the property is that they would send it for review, and then a government valuator would be appointed who would go and adjudicate over the matter and visit the property. But in and of itself, there's a lot of other issues regarding to that particular aspect. For example, there are issues related to how the BIR adjudicates over issues with respect to properties that may exist in a quasi-state. For instance, some properties may be both commercial and residential, or a property may have been, it is a residential property by all indications, but it is on a main road. And when the property was held by the previous owner, the vendor, which would have been maybe a decade, 2 decades ago, the zoning by the Town and Country Commission of that particular area has now changed to a commercial setting. But as it pertains to the indications with respect to how the property is constituted at that point in time, it appears residential. Who is to say at that juncture how that situation should be adjudicated? You would have the BIR indicating, well, listen, let's deal with it as a commercial property. The vendor saying, the purchaser saying, no, it's not, it's residential in nature. Town and Country saying, well, we have changed the zoning for that particular area. It is now commercial in nature. And then it is a question as to what is the possible or future intention in terms of usage for the property, which would affect stamp duty. So when we speak about fraudulent activity, that conversation as it pertains to BIR and stamp duty could take us this entire debate. Because in my short time in practice, I have seen all sorts of fraudulent activity taking place at BIR, all sorts of fraudulent activity. And I am not entirely comfortable just by simply registering an agreement for sale, that it would in fact stamp out that level of fraud that takes place there. I thought maybe I might have seen a requirement within that section where there's now going to be a list prepared of registered valuators, just like the bank would do it in some instances, or the banks do it in all instances, that you cannot just pick any Tom, Dick, and Harry valuator and present their documentation that would be taken at face value, that it must be from this approved list. And I think that as well, too, would stamp out a significant amount of fraud that occurs at the BIR when you're coming to deal with stamp duty and documents related as such. So that's my 2 cents in terms of that particular issue. And I thought it would have been best to raise it because I was still, maybe subsequent to the debate we could have that discussion and I may be enlightened a bit. Now, when I first read this bill, I must admit, as I indicated before, I am not a conveyancer in the truest sense of the word. And in the initial read of the bill, I thought to myself, well, we are moving in a direction that is not really objectionable per se. But just like most of the other senators within the chamber, I would have been issued with, the comments by the Law Association a couple of weeks ago, and I read them. I juxtaposed them with the bill itself, and I recognized then that there were some principles, some settled principles of conveyancing that this legislation was now infringing upon. One of the most outrageous aspects of it was the fact that title was not being passed upon signature or execution, but upon registration, which has been amended here in this new incarnation of the bill. But the real question, the real meat of the matter is whether or not the bill in and of itself would totally address fraudulent activities related with respect to the registration and conveyancing of land in this country. And last I was here, we were dealing with the real estate bill, and I gave an example then of how easy it is in Trinidad and Tobago for title to pass in a fraudulent way. That there are many matters before our courts in Trinidad where persons, legitimate title owners, for whatever reason, may not have been, as they say, minding the business with their properties, are now taking bona fide purchasers of property before the court because a fraudulent individual or a person who perpetuated fraud sold or pretended to act as a vendor for that particular property and sold it to this purchaser. And when I read the bill, that is what I was looking at to see whether or not the bill addressed that particular issue. I must say, in terms of comparison with what is here, and in my humble opinion, which could be to my detriment with respect to many practitioners in Trinidad and Tobago, I am a fan of the Roman Dutch system that exists in Guyana. I think the process is a bit longer than exists in Trinidad, quite a bit longer. But it is designed in that particular way to eliminate as best as possible issues related to fraudulent transactions. This particular bill, by the registration of the agreement for sale, some penalties that could be accrued for late registration, the ability for the Registrar General Department to adopt not really quasi-judicial functions, but a more active role in terms of conveyancing is quite similar to what exists in Guyana. And later on in my contribution, I will just run through the happenings of that system in Guyana. But the thing is, it does not in its entirety mirror the system. And I think based upon that, there are several loopholes that would currently exist. Is it a bill then that should be totally disregarded? My humble opinion is no. But what I do believe should happen is that we should take our time and possibly have it committed to a special select committee, or just like Senator C. Prasad would have indicated, a committee that could treat with this issue most palatably and aptly for persons concerned. Because it is a problem that has been far too long existing without proper attempts being paid to it to arrest this fraudulent situation that exists within our country. I indicated that in terms of the issue regarding fraud in conveyancing, the biggest problem is that we don't have a system set up, and the bill does not address it respectfully, where the actual ownership of properties can be easily located and identified. The bill would allow for persons to access the registry, which I have no problem with. They pay a fee, they access the registry. They are able now to see who these owners are. But not any individual could just simply do it. And I think that's one of the biggest problems that exists now. My humble opinion is that I agree. Either an attorney at law or clerk with the proper authorization as the bill purports should be the individual accessing the documents at the registry, because it would help limit the level of fraudulent activity that would take place if any individual is able to just simply access those documents. Because upon accessing those documents, the person could then initiate fraud by doubling as the owner of the property, engaging a purchaser to sell the property, and going through the process, as I indicated on the last occasion, of getting a fraudulent identification card, procuring an address document from one of those companies, Floor, whosoever it may be, and then actually going and engaging and selling the property sometimes 2 and 3 times over, just by simply having the agreement for sale being done, and no requirement at this juncture for having the agreement of sale being registered. So the fact that the agreement of sale is now going to be registered, as it is contemplated here, would help stamp that out, because there's a provision within the legislation, within the proposed legislation, within the bill, that would allow for the Registrar General's Department to be able to see if a particular agreement of sale has been registered more than once. And that to many persons, who, as Senator Hussain and myself and the Attorney General would have indicated on the last occasion, who spent the majority of their lives saving to purchase a property and have it vested in their name, it would help stamp out those fraudulent ones amongst us who would want to sell that property 3 and 4 times just by virtue of the agreement for sale. Because they take a down payment once, they go by Tom, they take a down payment from Tom, they go by Trevor, and they take a down payment from Trevor. And during that period of time, because there's no registration required currently, this person takes those down payments, he makes away with it. By the time you finish, go through the search process with your lawyer, and you're ready to execute, you can't find this alleged vendor. That is the position currently right now. And I said it on the last occasion, we have many matters within our court system where persons have gone through that process, and even went as far as having the lawyers conduct the searches, which they are required to do. Take the relevant information from the proposed vendor, ID card, proof of address, and everything like that. Search the property, bona fide property, good root of title, execute deed, title allegedly passed upon execution and registration and whatnot. And at this time, the person who sells the land or the house and land is not the actual owner of the property. What is your redress? You now have to go and find a lawyer, the owner of the property, when he or she becomes aware, to take action against this vendor, this purchaser. So this would help in great measure by the simple registration of the agreement to stamp that out. Right? Now, in terms of, I looked at, and I heard the Honorable Attorney General in his presentation with respect to the duties of the attorney to explain to the clients and whatnot. It's located on page 25. And I mean, it allows now, there's an obligation for certain things to be disseminated by the attorney at law to the client, and there are penalties now imposed if that isn't done. I'm just thinking, as it stands right now, we as attorneys at law have to take instructions, and those instructions must be signed by the client.
Senator Sobers, you have 5 more minutes.
Wow, yes, thank you, Madam President. Right, so we have to take the instructions, they have to be signed. And I mean, this I mean, anybody who goes to law school understands that that is the process flow of information, and if you don't, you can very well end up before the disciplinary committee. I'm wondering whether or not we are at the stage where we need to have this actually written into legislation for consideration at wrapping up. We can have that discussion. Also, in terms of the penalties, I'm seeing that there are penalties, so the penalties have been cut because before, in the previous incarnation of the bill, the penalties were quite high. That was an issue I had. But I'm thinking that's at clause 22. Some of the offenses that would require these penalties to be paid by the lawyers in terms of non-registration of documents and whatnot, I didn't get from the section whether or not there would have been an opportunity to indicate by the lawyer that this would have been based upon possible instructions by the client. I would have heard in terms of the submissions by the Attorney General that, in most instances, if you have a document that has been prepared and you haven't executed, it is more than likely that you are going to be involved in fraud. But I'm wondering whether or not we should at least have a provision just in case. It may very well be that it isn't fraud, and for some reason there may be a problem with respect to receiving comprehensive instructions and whatnot, if the client, for an instance, is incapacitated due to, And, in speaking to one or two persons, they've indicated that they still found, yes, the agreement for sale, the bill calls upon all agreements for sales to be done by attorneys at law, and no longer can it be done by members of the public. So that there's a bit of an expense that would now have to be borne by members of the public when they actually now have to go out and contract a lawyer to do the agreement for sale. I am a bit concerned whether or not the Registrar General's department is able to do what we are asking of them to do, because at the beginning of the bill, it calls upon them to be able to have all these new documents kept and whatever, the widening of the documents and whatever. And I'm wondering whether or not they're in a position of readiness, because the majority of the time, just to get a certified copy from the Registrar General Department takes quite a long time. So now that we are asking them to do more, we have to ensure then that they are properly well-resourced and they are able to treat with those issues. Now, I don't know how long I have again, but I just wanted to take this quick opportunity for consideration by the Attorney General and the government in terms of what happens in the Roman Dutch system. With respect to the same agreement for sale has to be entered and it has to be registered. There are searches that are done, and these searches are done by the lawyers to ensure that there are no encumbrances, good root of title. There are also other further searches done to ensure that no other agreements have been registered, and if there are, there's an application that could be made for termination, variation, and an order of priority with respect to those sales agreements. In terms of the agreement for sale also being registered, there are affidavits that accompany the registration of the agreement for sale. So there's an affidavit prepared by the purchaser, an affidavit also prepared by the vendor, just to ensure then that what is placed within the contents and the body of the agreement for sale is in fact bona fide. And then there's an instruction subsequent to that goes out for the transfer of the title to actually be advertised. And that would allow then for all and sundry within the public to know then what is actually taking place, who is the owners of the property that it is actually going to be sold. And if someone has an objection, they have an opportunity to file that objection, all in an effort to have proper transparency. And once there's no objections, it will then go to the transport court, well, the registrar's court for it to be transferred. And that is actually handled by the registrar's department to ensure it's bona fide. Madam President, at committee stage, we'll have a better discussion, but I thank you for the opportunity to present.
The sitting will now be suspended. We will return at 20 minutes past 1. When we return, Senator Dialsing will be the first speaker. And I trust, honorable senators, that when we return to the chamber at 20 minutes past 1. There will be a minimum of 10 senators in the chamber.